The courtroom smelled of old wood, paper, and authority, a place where reputations were made or destroyed in the blink of an eye. On this particular morning, whispers filled the air as the case everyone had been waiting for was about to begin. A complex dispute that had already made headlines was now entering its final hearing. Attorneys shuffled their papers, clerks tapped on keyboards, and the judge leaned back in his leather chair, wearing the smug expression of a man who thought he'd already won. The Honorable Judge Whittaker was notorious for one thing: crushing young attorneys who dared to argue before him. He believed the courtroom was no place for rookies, and he carried that arrogance like a badge of honor. When he glanced down at the defense table, his lips curled into something between amusement and disdain. Instead of the seasoned attorney he expected, there sat a young black student in a crisp navy suit, nervously adjusting his tie. His name was Marcus Carter, finally a law student who had been thrown into the fire. His mentor, the renowned attorney Richard Sloane, had been pulled into another trial across the city at the last minute. "Marcus, I trust you," Sloane had said before leaving. "You know this case as well as I do. Don't let anyone intimidate you." But as Marcus sat there, facing a room filled with skeptical eyes, it didn't feel like trusted, felt like being abandoned in a lion's den. The judge cleared his throat, leaning forward with a smirk. Well, Judge Whittaker said, his voice dripping with sarcasm. "I see the defense decided to send a student. Tell me, son, did you wander in here from the university library, or do you actually think you can handle a case of this magnitude?" A few chuckles rippled through the audience, and even the opposing attorney smirked at the remark. Marcus felt the heat rise in his chest, but he didn't flinch. He stood, straightened his back, and met the judge's gaze with steady confidence. "Your Honor," Marcus said clearly, his voice carrying across the room, "I may be a student, but today I represent the defense, and I assure you, I am fully prepared to argue this case." The room went silent for a beat. The judge raised his eyebrows, unimpressed. "Prepared?" he sneered. "We'll see about that." What no one in that courtroom realized, not the judge, not the opposing counsel, not even the curious spectators, was that Marcus Carter was no ordinary student. He wasn't just good at studying law, he lived and breathed it. His ability to absorb statutes, precedents, and case law bordered on photographic memory. More importantly, he had a sharp instinct for reading people, especially arrogant ones who underestimated him. As the bailiff called the court to order and the case began, Marcus silently promised himself one thing: he would not only defend his client, he would make Judge Whittaker regret underestimating him. And within the next few hours, the entire courtroom would witness brilliance that no one saw coming. The courtroom buzzed with anticipation as the prosecution's attorney, a slick and seasoned man named Thomas Reed, rose to his feet. He buttoned his tailored gray suit and gave Marcus a pitying look, as if the student had already lost before opening his mouth. "Your Honor," Reed began, pacing with deliberate confidence, "this case is quite simple. The defense's client is guilty of breaching contract, plain and clear. The evidence is overwhelming, the precedent is established, and frankly, this entire proceeding could be concluded in under an hour if only the defense hadn't sent us a student to waste the court's time." The crowd laughed again, emboldened by the judge's smirk. Marcus sat quietly, jotting notes, his pen tapping lightly against his legal pad. He didn't react, not yet. When Reed finished his opening argument, Judge Whittaker turned toward Marcus with a mocking grin. "Well then, Mr. Carter, the floor is yours. Try not to embarrass yourself." Marcus stood slowly, buttoned his suit jacket, and approached the podium. He paused, letting the silence settle, then spoke with calm authority. "Ladies and gentlemen of the court, the prosecution would have you believe this case is simple. But simplicity, Your Honor, is often the mask for sloppy reasoning. I intend to show that not only is the prosecution's argument incomplete, it directly ignores critical statutes and precedents that protect my client's rights." His tone was measured, his words precise, and for the first time the courtroom quieted to listen. Marcus flipped open his binder, revealing neatly tabbed sections filled with handwritten notes and highlighted cases. "The prosecution claims breach of contract, but as this court is well aware, under Johnson v. Hartwell, 1986, the definition of breach hinges on intent and material harm. The evidence presented shows neither. My client fulfilled every essential obligation. What the prosecution calls a breach is, in fact, a minor procedural delay that was addressed within the contract's grace period." Marcus didn't flinch. "Yes, Your Honor, page 417, opinion by Justice Harmon, a procedural deviation, absent intent to defraud or material harm, shall not constitute a breach of contract. Reed shifted uncomfortably, his face reddening. The tension in the air was electric. Judge Whittaker adjusted his glasses, the smugness gone, replaced with a sharp edge. He wasn't used to being challenged, especially not by someone who in his mind didn't even belong at the defense table. The audience gasped. It was a trap. Even most seasoned attorneys stumbled over dissents. They weren't always relevant to the case, but they were landmines for anyone who hadn't studied every detail. Reed smirked, confident Marcus would fall apart. The courtroom went dead silent. Then a ripple of murmurs spread like wildfire. Judge Whittaker's face hardened. He hadn't expected the student not only to know the dissent, but to turn it into a weapon for his own argument. Reed's smirk vanished completely. The opposing attorney quickly shuffled through his own notes, realizing Marcus might actually know the case better than he did. The judge wasn't ready to give up. Fine, Whittaker snapped. Then answer this. If we apply Harper v. Dalton, as you cited, wouldn't your client still be liable for damages due to procedural negligence, even without material harm? It was a clever twister question designed to box Marcus in. But Marcus saw the opening. With respect, Your Honor, that interpretation misapplies Harper v. Dalton. In that case, liability was only found when negligence created a measurable loss. In our case, there was no loss, only a delay. And as Your Honor well knows, delays within the contract's grace period are legally permissible. To rule otherwise would not only contradict precedent, but also open the door for thousands of frivolous lawsuits clogging this very court system. The words struck like lightning. For the first time, Whittaker shifted in his chair. His authority chipped away. The audience broke into low applause again, silenced only by the bailiff's gavel. Marcus stood steady, his shoulders square, his eyes unwavering. So, Your Honor, I ask again. If the law is designed to protect fairness, why should my client be punished when the statutes, the precedents, and the facts are all on his side? Whittaker stared at him, his jaw tightening, his pride bleeding out in front of the entire courtroom. He had tried to expose Marcus as an amateur, and instead, Marcus had made him look like the one unprepared. For the first time in years, the arrogant judge found himself speechless. The courtroom had transformed. Moments ago, it was a theater where Judge Whittaker reigned supreme, and Marcus was expected to be his comic relief. Now, the roles were shifting. The judge leaned back stiffly in his chair, eyes narrowed, while the spectators leaned forward, captivated by the young student who had turned the trial upside down. The prosecution, rattled by Marcus's composure, tried to regain footing. Reed rose with a stack of papers, his voice sharp. Your Honor, the defense is cherry-picking precedents and twisting them to fit a narrative. The fact remains, there was a delay, and any delay is a breach of contract obligations. End of story. Marcus stood immediately. Objection, Your Honor. That is a gross misstatement of contract law. The prosecution's argument ignores the doctrine of substantial performance, established clearly in Phillips v. Westland, 2014. Under this doctrine, minor deviations that do not defeat the purpose of the contract do not equate to breach. My client's performance met every substantive requirement. The delay was inconsequential, documented, and resolved within the time allowed. To call it a breach is not just wrong, it's dishonest. The judge's gavel slammed once, but it couldn't silence the hum of astonishment filling the room. Marcus didn't stop there. He stepped forward, his voice rising with conviction. Your Honor, the prosecution is asking this court to set a dangerous precedent, that technicalities matter more than justice, that contracts exist not to guide fairness, but to punish ordinary people for minor errors. If we allow that standard, then every contractor, every small business, every worker who makes a human mistake could be ruined, even when no one was harmed. He paused, letting his words sink in. His eyes swept across the room, not just addressing the judge, but the spectators, the prosecution, and even the stenographer. Law is not about arrogance. It is not about who speaks the loudest, or who wears the most expensive suit. Law is about truth. And the truth here is clear. My client did not breach the contract. The facts show it. The precedents confirm it. And justice demands it. A hush fell over the courtroom. Even the harsh fluorescent lights seemed to dim in the gravity of his words. Judge Whittaker opened his mouth as if to retort, but no words came. He shifted uncomfortably, clearly battling his pride. Everyone knew the law favored Marcus's argument. To deny it would expose the judge, not the student. Finally, the gavel came down. The court finds in favor of the defense. The case is dismissed. For a heartbeat, Silence. Then the room erupted. Applause, cheers, and stunned murmurs. Reporters scribbled furiously, already preparing tomorrow's headlines. Law student stuns courtroom, outsmarts arrogant judge. Marcus gathered his papers calmly, though his hands trembled with the release of adrenaline. He had done it. Not only defended his client, but shattered the arrogance of a man who thought the courtroom belonged to him. As he walked out, people whispered his name. Some shook his hand, others simply stared, as though they had witnessed history. Judge Whittaker sat frozen, humiliated in the very place where he once held absolute power. And Marcus Carter, the black student no one believed in, had proven that brilliance, courage, and truth could topple even the highest walls of arrogance. That day, the courtroom didn't just see a case win, it saw the birth of a legend.